Investigative subpoenas, Chris, they are believed to be abused. They are believed that they are used as a coercive tool to get people to say what prosecutors want them to say. Can you talk about investigative subpoenas?
Investigative subpoenas are done, it's a legislative authority. It's a law passed by the legislature, and it's not necessarily we do it on our own. We have to go through a judge. It's much like a search warrant. We have to petition the judge has to sign off on it. We only use them in the most serious cases, typically homicides. And the homicides that we use them on are the homicides that we're not getting cooperation. We don't use them on every single homicide. If GRPD or Kentwood PD or somebody is getting witnesses who talk to the police and are giving us information, we're using them as a last resort. Unfortunately, and that's what we're trying to have this dialogue is, there is that mistrust, and what the mistrust that he's dealing with affects how we are able to close out investigations. So we use those when they're not getting the people talking to them because of whatever issues. We are using investigative subpoenas to go out and try and solve these very serious crimes that people are generally dead. I mean, I can't think of too many other cases where we use them other than the homicide case where we have a dead body, and once again, going back to the victims, a victim's family who says, wants us to pull out all the stops. They have a loved one who has been killed, and we can't just throw up our hands and say, well, nobody's cooperating, we're not going to do anything. So those are the situations we use them, and yes, we try and not use them just to throw out candy. It's a thing of last resort.
But how is it that you are able to determine when you turn around and charge a person? Understand something. When there's an investigative subpoena for homicide, if you're charged with perjury, the same penalty for that perjury is the penalty for homicide. So if it's a life offense, you're charged with perjury. If you're convicted of a life offense. That's a pretty big stick. How do you know now that this person is not telling you what you want to know, based on to get out from under the charges?
Based on the perjury charges, if we're filing a perjury charge, we have other evidence. It's not just what the person said. We have other evidence. Very often, it's cell phones. Sorry, I'm going to use yours, but cell phones. We have cell phone records. We'll have text messages between the two parties, and somebody will say, well, I never talked to him. I never had any text conversations with him. And we'll have 20 text conversations between them. It's not like it's a close call. Well, somebody said one thing and somebody said the other thing. We have text messages, we have video, we have other hard evidence to support the perjury charge against that individual. And it's not like we just, we throw you up on the stand and have you testify. By statute, we have to go through, we read your rights. It's a process where we go through. You have a right, you're going to be, this is an investigative subpoena. If you lie, you could be, held accountable, you could be charged with perjury, and we tell them what the penalty for perjury is before we even start the questioning. So it's wide open. Here's what it is. It's all on videotape. So if anybody's got an issue with it, it's on videotape, so they can take once charges are filed, we provide you with the videotape. The videotapes go to everybody. And then at the end, after we get the testimony, they're given an out. Okay, and there's by law, we have to give them, okay, everything you've testified to, here's your chance. Here's your chance to change your statement. If anything you've told me right now is a lie, not truthful, anything like that, you can change it now and not face charges. So you tell them ahead, you tell them afterwards, and then, people still don't tell the truth, even, and for a variety of reasons, whatever it may be. But to get the information, then we confront them with the fact, we've got these text messages, you did lie, why don't you tell us the truth?
Well, the perception is that when you put a person under investigative subpoena and turn them into a witness, and they make a statement at the investigative subpoena, not after this investigative subpoena, but after you charge them with perjury, is that it's coerced. That it's not true also, that they will manufacture whatever they need to say to get out from under that perjury charge.
But once again, I go back to, we usually have the hard evidence to say what the information is that we have. What you testified to was clearly a lie. We have a text message of you conversing. We have the GPS, talking about GPS, we can track phones. We have you in the area. You weren't up in Rockford at the time this happened. Your phone is bouncing off the cell phone tower over on the southeast side. So we have the other hard evidence to back up whatever the true story is that they give us after they've lied. So it's not just a he said, she said, or they're just making stuff up after we have the hard facts to go along with their testimony.
What do you think of the fact that if a person just sits there sat there and refused to answer the question, it's a 1-year misdemeanor. If they refuse totally to cooperate and they say absolutely nothing to you, it's a 1-year misdemeanor, which means they'll do what, 10 months?
That would be up to the judge. That, that's, obviously that's their call in terms of what they make. We're just looking for cooperation to, as long as they come in and tell the truth, tell the truth. I mean, we understand there are situations where you may have to tell about a friend, may have to tell about a loved one. But we're, again, balancing on the other side, we have a dead body here. And so that we're trying to get to the truth of what happened. That's what we're trying to get at. And if they don't want to testify and they want to take the misdemeanor, I guess that's their prerogative. That's their choice. But if they just come in and tell the truth, they don't face any charges, and we can proceed along. We don't want to do this. It's not something we want to do to charge people and get them caught up in the criminal justice system. But given the high nature, the high stakes of what occurred, it's something we feel is necessary because we're not getting the level of cooperation. If we can get the level of cooperation, we build in these police, community relations, and they talk to the police, and we can build a case. I would love it not to be able to use these, but we have to use them in certain situations.
Well, Chris, it's been my personal experience that they're abused, and quite frankly, I give you a lot of credit because I brought that to your attention, and you dismissed one. You dismissed the perjury charges, but not everybody has that option. Not everybody can be able to say, will you look at this?
Sure they do. I mean, I try to be as open as the chief, and if somebody calls and they have an issue with a prosecutor, a charge I've done, I'll take a look at them. I don't always, in your case that was a unique situation. Okay, we'll do it in that situation. But I think ultimately that is my job. I am I'm the chief law enforcement officer of the county. It is my role, and so if somebody wants to call me and say, hey, this is unjust, I will definitely take a look at it. I won't maybe do it all the time what you want, but that is my role, and everybody has that opportunity, whether it be you, whether it be a member of the public. I really try and respond to all my phone calls, emails, whatever it may be. Not good on Facebook, though. Don't try Facebook. I'm not.
Yeah. Commissioner Woman.
Yes, I know a number of people that are going to prison for perjury. And we should have a constitutional right to remain silent. If you are brought in on one of these these investigative subpoenas, and you can't even say, I refuse to answer, because you can go to jail a year, and you don't even have to lie exactly like he said about the case. It was like, have you talked to this person? Now, we've been also talking about mental illness and people, and now we have a mental court for those who are going through mental illness, so we can keep less people from going to the county jail that should be in other facilities or receiving help. But how do you know this person really can't remember? Are they really getting some psychological evaluations? You could say you don't remember talking to somebody. I know a person going to prison, and it was only one. They asked the person, did you ever put on Facebook something about one of your family members? They said, no, I never put it on Facebook. Well, the person didn't know that your message, which is actually another app, Facebook and Messenger, even though they work together, they're two different apps. So this person, it feels, you didn't ask me about Messenger, you said Facebook, so that person thought, of course I didn't publicly put out there my family's business. But one message, and this person is going to prison. It's already a set deal. They're waiting for sentencing. That is something that just seems unconstitutional. I'm going to wrap it up quick, and let's give it up for our moderator, because he had some great questions today. He introduced all us, but I don't have a lot of questions because he asked them all. Anthony Green, you did a great job. But I just want to also say, when it comes to, I want to keep this quick, I didn't get a chance to talk about the plea bargaining. The plea bargaining, 90% of federal cases, I think it's like 95% of federal cases are done by plea bargaining. It's a little lower when it comes to state, but the majority are done by the state. And when it came to Missouri versus Frye, U.S. Supreme Court Justice Kennedy, who is now about to retire and resign, he said it was like horse trading when he looked at the plea bargain system in the United States of America. Then in 2012, in the United States, Brady versus the United States, the Supreme Court came out and said, okay, we're going to continue these plea bargains, but you must have adequate counsel. There cannot be any threat made to you. There cannot be any promises made to you for a plea bargain. And if you've never dealt with the courts, which I have, I don't know a plea bargain that's ever been made that didn't either have a threat or a promise or some type of combination of those. So even our plea bargain system is unconstitutional. So there's no way we can really sit up here and talk about plea bargains and say we're doing them all correctly. And if you have never dealt with the justice system, maybe you need to ask someone in your church, someone in your neighborhood who has dealt with the court system. I thank the ACLU for having this. I do thank Chris for being the most open, communicative chief prosecutor we've ever had in the county. I'm not here to try to argue with him. I'm definitely not going to try to beat up on him. I think that when leadership attacks people who are ready to talk, we're doing our community a service, because once we shut down communication, there's no room for growth. So I definitely thank him for being here, but I do think we need to look into these things.
I'm going to go to the floor.